I'm Robert Shapiro, Chair of the International Trade Group here at Thompson Coburn. And with me are Terry Polino, Arisha Gamel, and James Burnett. Welcome to the presentation on mergers and acquisitions in trade issues with mergers and acquisitions. Our goals here are going to be to discuss international trade regulatory issues in the mergers and acquisition framework. While we may touch on some issues that are broader than that concerning foreign corrupt practices or national security and CFIUS, it's not going to be the goal of the discussion. We're going to focus on customs compliance, export controls, and economic sanctions. We're also going to be focusing on pre-acquisition activities. So these are the activities that are trying to identify the risks associated with a particular acquisition, a particular target company. We will try to mention at different times how this plays into integration activities and the importance of that. We're going to be focusing on those activities that have to do with due diligence in the pre-acquisition framework. We're also going to be working from a case study. We've set up a hypothetical target company. We'll be discussing some of the facts of that target company and applying those facts to some due diligence observations and how to get through that. So we want to first start with what makes the due diligence environment special. Why is this different than another compliance review? And so there's a couple things here that are really important. One, you're dealing with limited information. So in a normal compliance review, a compliance officer will typically have access to a lot of company information and records and being able to prove out compliance. But here you're going to have very limited information, so you're working from that basis. The timelines are usually tight and are externally driven. They're driven by the nature of closing on the deal by certain contractual terms. The goal is really to identify risk and to estimate potential liability. You're going to be scoring risks as high or low, medium, and then trying to estimate the potential liability, but you're not likely to be able to get to the level of precision that one is used to in a compliance review. And so it creates a bit of a uncomfortable position at times for a compliance person to try to estimate those risks that way. The end product is something that the deal people can use in negotiating the transaction. So we're looking to make sure that we recognize the risks and can in the future receive the benefits of the transactions proposed. This also can be a bit of an iterative process. So you'll get some information and dig down a little bit further with further queries. Why is due diligence important? Well, there's a couple things. I mentioned previously that we have obvious concerns about the value of the deal and trying to determine what the value of the transaction is, and those risks can affect that value on a going forward basis. If the company doesn't have good compliance procedures in place, you may not realize the benefit of the deal that one was anticipating. But the other is the liability for past violations, and that's we refer to as successor liability. So will the purchaser or the company be liable for the violations that occurred prior to the acquisition? Now, this in some ways doesn't seem fair, but there's a lot of decisions by the government finding that a successor company is liable for these prior violations, and it can be on a number of bases. So successor liability generally will attach if there is a substantial continuation of the violations of the predecessor. So if in due diligence you find that there are risks of violations, it becomes important in the integration process to correct those procedures to avoid successor liability for the successor company for the predecessor's activities, even if those are disclosed and absorbed by the predecessor company. So in that way, good due diligence is important to a smooth integration after the acquisition is completed.
As Robert mentioned, today's presentation will partially take the form of a case study. Throughout the presentation, we will be presenting sample data and raising issues related to our fictional acquisition target, which is World of Widgets, or WOW. WOW is a U.S.-based engineering company that globally manufactures and distributes widgets used in a wide variety of applications, including computer electronics, aircraft, oil and gas, automobile, and medical. The company has locations in the United States, where it is headquartered, as well as Germany, Korea, China, India, and Russia. WOW is a globally operating company. It has centralized procurement, and it purchases goods for delivery to manufacturing facilities located globally. Engineering is done both in the United States and in India through an Indian subsidiary. The company has sales agents who work with customers to specifically design products for those customers. Sales from the United States to foreign customers are also made through foreign sales units.
So the first area that we're going to go into before we sort of drill down into specific import and export issues is sort of an overview of the compliance environment. Obviously going to be applicable whether you're talking about import or export compliance. And primary at the top of that list is the tone at the top. You're going to want to find out, is there a company compliance statement? Does the company have a trade compliance department? Are there international trade compliance manuals and procedures in place? These are three key aspects of determining what the level of risk may be within the company. Let's just take a quick look at these three elements. We have a compliance statement here, which I'm not going to read. People can read on their own, and people will have access to these slides afterwards if you want to take a closer look at it. But we put it up here because in some ways it's a good starting point for a compliance statement, but really, if you read it closely, it's not sufficient. It has things missing. It probably has irrelevant items. For instance, there's no reference to import regulatory laws or export controls and sanctions. There's no guidance on how and to whom to report concerns. There's references to a specific state law that probably isn't relevant to an international trade compliance statement. And it references the fact that the statutes, regulations, and guidelines that must be followed are those applicable to a nonprofit organization. And as we found out previously, this is a for-profit company that we're talking about. So clearly, having a compliance statement alone is not sufficient. You need to make sure that the compliance statement says what it's supposed to say, what it needs to say within an organization for international trade compliance purposes. The second area that deserves a little further review in the due diligence is looking at the compliance department, assuming there is a separate compliance department, or at least people who have that role and responsibility and function within the company. So how is it structured? How many employees are dedicated to the compliance function? Do the same employees perform the day-to-day functions and the monitoring functions? These are sort of factors that there's not necessarily right and wrong answers on these. It's how the company operates. But when you put the whole picture together, going down the list, things like what are their levels and titles, their level of expertise, the training they get, you start to get a sense of the level of risk. Does the company really have a well-structured compliance department with people who've been doing their job and are well trained, or is it that it's catch can in terms of who does what? Also, where does this structure, this function rather, fall within the corporate structure? We have the next slide to kind of help visualize this a bit more. So when you're looking at trade compliance, normally it doesn't sit by itself. It sits within another place. Where does it sit? Are there better places than others? If you see compliance sitting within sales and purchasing, that may be a bit of a red flag because the goals and objectives of trade compliance and sales and purchasing are probably going to be at odds with each other. Logistics may also have some issues on because you've got the operational side that's focused on just moving goods and getting them in quickly. But if you've got your trade compliance and especially the monitoring side, looking at making sure the standards of compliance are maintained at a high level, that can present some conflicts as well. So where should it be? Well, again, there's no right or wrong answer here in one sense, but legal is sometimes a good place to find trade compliance. tax and finance, especially on the import side, may be a good place to find it. And speaking of on the export side, Robert, thoughts on that?
I think there's several places where trade compliance could be located. The one that would raise an immediate concern, at least a risk concern, would be having export compliance in the sales department, just because there's often a conflict of interest between export compliance and sales. Another place where you may see it is in engineering or product development, and that also can raise some concerns because of the nature of their activities and the fact that their activities are so often subject to export controls. We've also seen it in accounting, which is a good place because of its general independence from the operations of the company.
So hand in hand to where it sits is what it does vis-a-vis all these other departments. As we had on the previous slide, the interactivity among the relevant departments, the communications. It's important to have an open line of communication and cooperation for these departments if compliance is going to be, again, maintained at that high level. So when you're taking a look, and we get to the next slide on manuals, that may be one of the places to look to try to figure out, is trade compliance trying to do everything on its own, in which case it's probably not going to be that successful, or does it have good lines of communication with all the other departments in the company who have and who touch on the import or export of goods or materials?
So related to that interaction with the other departments, while trade compliance, it's best if trade compliance has some independence, it needs to be able to closely communicate and work with the engineering and sales, for example, the two departments where I said are cautionary for it to be located, needs to work closely with them. And as we'll address in the compliance manual on the next slide, the documentation of how these communications work give a good indication of risk. So lack of documentation on those communications would be a signal of a slightly higher risk, and good documentation would identify a lower risk situation.
Yeah, following on what Robert just said, remember what we're trying to do here largely, and certainly in the first instance, is really just get a handle on what the risk level is. And there's often not the opportunity to be drilling down, for example, to specific transactions, and things have to stay at a high level. So one of the tools that can be used is looking at the compliance manuals and procedures. First of all, do they exist? Obviously, if they don't, that's probably a big red flag. But assuming they do exist, just take a look at them and make sure they're specific to the company. They're not some off-the-shelf generic procedures that really don't deal with the specific company or its industry. Take a look at how often they're reviewed and updated. Is there training that goes along with the manuals, both to update people on when there are changes to the manual, and also to make sure new people are trained on the manual, are aware of the manual, where it resides, and what sort of information is there. And as we just said on the other slide, the previous slide, you also want to make sure that the procedures are such that they're really interactive with the rest of the company, because Trade Compliance Department is never going to maintain a good level of compliance if it tries to be a world unto itself.
So moving on to our next section here, let's talk a little bit about the import due diligence that should be performed in an M&A environment. We'll take a look in the import section at a number of risk areas that are often associated with these types of transactions. These include classification, valuation, free trade agreements and preference programs, record keeping, anti-dumping and countervailing duty, and country of origin. So going back to our scenario that we presented a little bit earlier, we want to consider whether WOW has an import product matrix that lays out the classifications and the part number detail about its products. We would also want to ask whether the company has recently obtained iTrack or has access to their ACE data, and whether they are willing to share it and how they've used it, whether someone's reviewed it or and what type of analysis has been performed on it recently and leading up to this point. Additionally, we would like to consider whether the company conducts periodic post-entry audits and compliance reviews. And again, to the extent the information is available and the company is willing to share it, consider how often those reviews are done and by whom and who they're reported to evaluate whether they are thorough and what level of risk can be assessed from them. Finally, we would like to know what the company's level of interaction is with CBP. Are they actively filing protests prior disclosures? Have they been participating in TEEs or ISA? Have they been subject to an audit or focused assessment? These will all help us assess the risk as well. So looking at some sample data we have from WOW, the top portion of your screen is an excerpt from an iTrack report that is an aggregate report showing the top classifications by value going back to 2013. And the bottom shot is the product matrix for this company. So one of the first things that I see looking at this data is that the product matrix itself is categorical in nature. It's not part number specific. It also has some unusual classifications for this business and some obvious classification errors. For example, the screws are classified according to the product matrix in a provision for footwear, which is both unusual for the company and clearly incorrect for screws. Another issue that I see looking at this data is that there's a significant use of Chapter 98. Heading 9801 is for U.S. goods returned, and so anytime we see a Chapter 98 provision, it's good to try to drill down on the background of it. Do those goods actually qualify? Who's made the determination that they qualify? Do we have support for that? Another issue, and this is a bigger issue perhaps than the others, is the anti-dumping concerns that may come out. Anti-dumping and countervailing duties are priority trade issues for customs, and these can potentially grow to a very large liability in a short period of time. So on this data, we see articles classified in heading 7208, which provides for other flat-rolled products of iron or steel. Steel plates from China are currently subject to anti-dumping with a PRC-wide rate of 128.59%. So just looking at this little snapshot of data we have, that's potentially a 3-year liability of $4.3 million, which can be quite significant when you are trying to assess risk. And then the final thing is that the classifications used for the airplane widgets and the car widgets are parts provisions. What often happens is that when such generic classifications get used for parts, general purpose articles are often misclassified as those parts. In this case, there is a significant amount of classification under parts, but then we also see motors, which can sometimes be misclassified as parts, being broken out into their own classifications. We see rubber gaskets and even an attempt at breaking screws out into their own classifications. So that seems to indicate that maybe the products that are classified as parts do actually belong there. So overall, the goal is to balance the information we have available to assess the level of risks associated here. So also what we see from this data is a couple areas where there are opportunities for some duty savings. For example, the screws appear to be incorrectly classified under 6404, which is dutiable at 20%. Screws are generally dutiable in the range between 0 and 12.5%, and while that's a wide range, it's still significantly lower than 20%. So there may be an opportunity to recover duties for the last year and a half on those screws. Similarly, the titanium widgets. The product matrix currently classifies titanium widgets under the provision for titanium bar. However, articles of titanium are classified at 5.5%. So depending on what those widgets are and how developed they are from the raw material, there may be some potential for savings here as well.
So moving on to the valuation and what we can glean out of the information, again, that we can get at a high level. The iTrack data gave us some information by year on number of entries and total valuation. When we look at that, information, there's some issues that come to light, in addition to some of the more general issues that you're always going to want to consider when you are looking, when you're doing your due diligence in an M&A situation. For example, how exactly is valuation being determined? Who's determining it? We have a related party here. Has that related party transfer price been validated if that's what is being used for the customs valuation? And obviously, you don't want to just hear that, well, of course, our tax people do it because they know it's right for tax purposes. There's a different validation method for customs, and so it's good to find out if people are cognizant of that and if that's also been done as well. And if there is a transfer price being used for valuation, is there a transfer price adjustment that occurs periodically, again, for the tax purposes, but that may, most likely, is going to affect your customs value. So how is that being dealt with? Is the company on reconciliation, for instance? And are they appropriately handling upward and downward adjustments? And some of the other general areas that bear some looking into is how do they do business in terms of the manufacturing plants? Are assists provided to those plants? Do they provide the materials, the tools, the tooling, the equipment, the production equipment, R&D? And if it's R&D, where's the R&D done? Are supplemental payments provided? And again, these would be appropriate questions for across the board, not just to the related parties, but is there funding of a plant up front? And then that's taken against the price later, and if so, is that handled appropriately for customs? So looking at the data itself, though, we see this trend where things stay fairly constant for a couple of years, and then there's a significant increase in 2013. Significant import increases, either entry and or value, often catches the eye of customs, and they're curious as to what happened there. New product lines, different method of valuation. So they may look, and it may behoove you to look as well and find out what caused that. We also see, if we look on to 2014, things went down kind of to normal, or what they had previously been. And then the projections for 2015 are a bit erratic in that entries went up and value went way down. That for sure is going to warrant some questions as to why it is that's happening, because you might normally expect to see those trends to be somewhat in line with each other. So those are the sorts of value issues, and again, trying to look at the data that you can get at a high level and the information you can obtain on their operations at a high level, just to determine, are they doing things that may lead to a high risk, or is it more of a low risk operation?
The next category we want to take a look at is free trade agreements. Now, claims under free trade agreements are also a priority trade issue for customs, and they do receive higher scrutiny from customs. So this is an area that could potentially be a high-risk area if these free trade agreements and preference program claims are not proper and cover products that aren't eligible. So looking at this snapshot of data, it's clear that WOW has had a significant and consistent use of various free trade agreements and preference programs, including NAFTA, Korea, the Agreement on Trade of Civil Aircraft, and GSP. So the types of questions that we'd want to ask to assess the level of risk associated with these claims are, who performs the eligibility analysis for each of these products? Are they done by WOW, by the importer that is making the claims, or are these claims based on just an analysis that the supplier did? Is there supporting documentation to back up these claims? Who instructs the broker to make the claims? Again, does the importer give these instructions to the broker when to claim and when not to claim, or is the broker just going off of the documentation included with the shipment? And finally, are periodic reviews performed to validate each of these claims? Is someone reviewing this documentation and even looking behind it to look at the production records or the materials used in the production to make sure that the products do in fact qualify under these agreements? And the level of information that is available or is not available would help you assess the level of risk associated with these claims.
So it was mentioned earlier that one of the other areas is how does the company interact? What sort of interactions has the company had with CBP? In your due diligence checklist, you're going to want to include requests for documents relating to these types of activities or actions and see what you get back. We've kind of divided them up here into a high, medium, low risk. Obviously, sometimes it doesn't always work that way when you look behind it. Maybe something goes a category up or a category down. But these are the sorts of things you want to look at in order to assess where in terms of the interaction with customs would I say the company is. Are they in the middle of a penalty action? You probably have a high risk there. What's going to happen with that penalty action? Who's going to take responsibility for it? How high is it likely to be? Or at the other end, have they completed a focused assessment with and came out with flying colors, and so you know they're looking good in customs eyes, and they probably have some good processes in place that got them there.
And finally, country of origin. Now, assessing country of origin in this type of environment can be challenging because of the lack of information that is often available, and country of origin becomes particularly difficult to determine because you often can't tell the accuracy of it just based on high-level data that you may have access to. So in the lower risk concern category would be country of origin declarations or the markings on the product. The bigger concerns relating to country of origin pertain to anti-dumping and countervailing duty applicability and free trade agreements and preference programs, since both of these are very much contingent upon getting the country of origin correct for the product, and that they're tied to the origin. So errors of the country of origin can therefore impact the eligibility or whether a product is covered by a dumping order and pose a high risk. Government procurement is another area where country of origin is critical, and declaring or providing an incorrect origin in that context can have some serious repercussions. And finally, even though we said that country of origin marking on the product may be in a lower risk category, if there is discrepancy between what the marking on the product says and the documentation or declaration that accompanies that product, that can put you into a higher risk category, because your risk of having the product detained at the border or refused admission becomes significantly higher when there are such discrepancies on the face.
And finally, on the import side, before we move out of imports, and Robert had indicated that we would try to also touch briefly on sort of integration things. And some of those things that operational aspects that while the due diligence is going on and as it appears that a deal is really going to go through, that the operational side wants to or should consider as early as possible so that the integration can be as seamless as possible, or things such as, will the new company, the acquisition company, continue to do business under the same importer of record number, under the same name, at the same address? Will a bond change be necessary? Will it be necessary to file a new 5106 with Customs, apprising them of any of the changes to the things we just mentioned? Are vendors being notified of the changes and how to do documentation? The SOPs and manuals all need to be updated. Looking at brokers, are they going to remain the same? Are there POAs out there that need to be terminated? Are there new POAs that need to be filed? So those are the sorts of things that one also wants to look at from an operational side to try to make sure that once the deal goes through, the integration can be as quick and seamless as possible.
Okay, so now we're going to do what I always refer to as putting on my other head, which is the export controls and sanctions side of a mergers and acquisition due diligence. We're going to look at a couple different areas. We've got classification, similar to classification issues that are related to but different from those on the import side. We have to deal with both exports of hardware and technical data, and since WOW has a development office or design office in India. We'll have particular concerns with that. We have to deal with re-exports and not just the initial export. We got to look at embargo destinations, denied parties, SDNs, how screening's being done for those. We have financial dealings that we need to consider also, because even transactions that may be authorized may have issues regarding the banks that are involved. And then we have foreign subsidiaries and U.S. employees abroad and the roles that they may play in bringing the U.S. company into involvement into transactions that could not be done by a U.S. person, but could be done by a foreign person. We have a couple things to look at for export sanctions due diligence for WOW. So the similar question that we had on the import side, does WOW have an export product matrix? It's really hard to do any of the compliance work without first understanding what a product is and how the product is controlled and classified. Is export sales data available so that we can identify what countries goods are being exported to, which goods are being exported where? Does the company perform denied party screening? Believe it or not, there are a lot of companies that will do the screening by a manual process of just trying to review the list in the regulations, which is a really hard way to get this done. So the next question is software being used, and what transactions are screened? I would add to it, sometimes companies screen only transactions in certain areas and they miss others. The other question is, when are transactions screened? Are they screened at booking? Are they screened at the time that they're about to be shipped? Has the company been subject to any export-related investigations, inquiries, or penalties? Has it filed any disclosures? Does it have any export license applications? Has it received any licenses in the past 5 years? All those are indications of its knowledge and ability to do export control.
So with all these issues in mind, a great place to start is with the company's export classification matrix. These will be the export classifications for its products, where they are located on the Commerce Control List, located on the U.S. Munitions List, or alternatively designated as EAR 99. This initial piece of data is a great place to begin. It kind of develops a roadmap for the company's export activities and serves to identify risks located in the company's business line. So the first question you really need to ask a company is, do you have an export classification matrix? If in fact they do, this is a good start. But even when you see that matrix, there may be some red flags that you want to identify early on just to see what the risks associated with this acquisition are. So for example, the company may universally designate all of its products and services as EAR 99. This may be accurate and possibly means that everything the company makes can ship to most countries without an export license. Unfortunately, that EAR 99 designation also means that the company can ship, or at least thinks it can ship, everything to most countries without a license. This may be shorthand for the company not making enough, or in some cases any effort regarding its classifications. In other cases, the company may have come up with incomplete classifications, getting instead to the jurisdiction, saying, well, these products are classified on the ITAR. These products are classified on the Commerce Control List. In that case, they have not taken enough steps to find out what the exact classification of their products are, which determines the export licensing requirements associated with those products. In some cases, they may have even drilled down, but they have used incorrect classifications. We've seen that this is a particular problem for companies that have products that have undergone the export control reform process. That is, changing from the jurisdiction of the Department of State on the ITAR and the USML over to the Commerce Control List and the jurisdiction of the Department of Commerce.
Sometimes the classification stuff, James, is hard to get to, and there's some tools available. If you can determine that the HTS is right, you may be able to look them up in customs info or something else to see if they're likely to be classified someplace else under those provisions.
That is very true, and a good resource. So some other issues that come up with this is that when you've made a classification determination, particularly under the new specially designed rules that are associated with export control reform, the documentation of those classification determinations is really important with regard to making sure that your classifications, 1, are correct, and 2, if questioned by the Department of State or the Department of Commerce, will be defensible. That documentation aspect is another place to look in terms of classification. So once you've identified the universe of products that the company has, and particularly if they do not have export classifications associated with them, you want to perform something of a risk assessment to determine what level of risk the company is subject to. There are high-risk exports, such as military, oil and gas, precious metals, petrochemicals, which, as we've seen in our case study, WOW does a little bit of these kind of exports. Some lower risk, and we say lower, not low, since you will need to still make a determination, even if your items are located in these, would be medical, clothing, food, items such as that. Now, the next item you'll want to request after you've got that export classification matrix, or at least some idea of what the company is exporting, is their export sales data. Here we have a sample from WOW of export sales data. Obviously, it's not their entire sales history, but it is a fairly risky snapshot of some of their sales history over the past couple years. Once you've seen this, once you get a hold of this data, what you want to do is identify the risks, but once you identify those risks, you want to kind of pull the thread and see where it takes you. You want to identify the risk and then identify the issues that those risks raise. So when doing this, you want to ask a couple of questions. And I look at it as a 2 whats, a when, and a where. First, you want to ask, what is missing? For one example, in the first line, we have a sale of automotive parts to WOW Germany. This is World of Widget's German subsidiary. What's missing in this transaction? Obviously, it would be, who is WOW Germany selling to? Is there a downstream customer associated with that? While the company may be able to ship those items, those automotive widgets, to its subsidiary in Germany, the German subsidiary may be prohibited from exporting those automotive widgets, regardless of classification, to certain countries downstream, particularly those subject to embargoes or sanctions like Iran or Cuba. So in this case, what is missing is the shipped to and sold to data, and it's something that you'll want to request and see if the company has. The second what would be, what is being shipped? For example, you'll want to know, 1, the export control information regarding the product. You'll want an in-depth product description, and in many cases, the end use or the platform for which that item is going into. We see a high risk here with a shipment of a computer electronics widget to an aerospace company in China. China is subject to certain arms embargoes under U.S. law, so this sale, where there's no end use or platform data and you don't know exactly what the widget is going into, should raise a lot of red flags. It's definitely something you want to follow up with WOW when going through their data. So the third question would be, when did the shipments occur? Timing in export controls can be very, very important. As we mentioned earlier, export control reform changed a lot of classifications, but also in a sanctions context, you see timing being very important. In one of our lines, and that is product number 1000 at the very bottom, there's a shipment of an oil and gas widget to Gazprom in Russia. Gazprom is a target of OFAC sectoral sanctions, that's the Office of Foreign Assets Control and Treasury, and subject to certain EAR export restrictions concerning the development of oil and gas development activities in Russia, including Arctic offshore, deep water, and shale. These restrictions were actually implemented in 2014, while the shipments we see here occurred in January of 2011. While these 2011 shipments aren't subject to the current sanctions regime imposed against Russia, they are indicative of a risky customer and our ongoing relationship that, well, I'll say a relationship that could be ongoing. And it's something that you'll want to follow up with. Check the more recent sales data to make sure that these items, oil and gas items, are not being sold in violation of sanctions, even though they may have been allowed earlier on. So finally, the last question you want to ask is, where are the shipments going to? You'll see one very obvious red flag in the second line, which is a shipment of medical widgets to a hospital supply company located in Iran. Obviously, Iran is subject to U.S. embargo, OFAC sanctions, but the shipment raises several issues regarding these sanctions regimes. Was an OFAC license used for this shipment? Are the items even eligible for shipment under the Iran General License for medical equipment? How was the sale financed? Were there any specially designated national banks involved in the financing of this? And was the sale screened for denied parties?
So we also have to deal in the export control framework with technical data exports, and these are traditionally very hard for companies to get a hold of. I mentioned earlier concerns with the Trade Compliance Department being in sales or engineering, and that's because the sales and engineers often are dealing with technical data and sharing that. So one of the things, and I referenced it before, is we have to consider WELL's relationship with its Indian engineering subsidiary. What products or product lines are being developed in India? Does WELL have any access controls on its systems to make sure that the Indian engineers are not getting access to controlled data unless it's licensed or approved? Do they have any licenses in place with India, any TAAs or MLAs in place, or any export licenses in place for dealing with India? Are these controls documented? If there is a TAA in place, is there documentation in place on how that TAA is to operate? Technical Assistance Agreement, TAA, under an export license for the State Department. We may have controls on the technical data from a commerce perspective also that need to be licensed. We have to look at foreign national employees, both in the U.S. and outside. Are there procedures in place for making sure that foreign nationals are not gaining access to controlled technical data without authorization? We have to also be concerned on the outward-facing side of this. It is mentioned in the fact pattern, WELL specifically develops its products for its customers. So are they sharing technical data in that engineering activity and that design activity with their customers? If they are, have they put procedures in place to control that technical data if necessary, or to get authorizations for those? And we're going to be looking for samples of that information as part of the due diligence. WELL also has, as James had pointed out, they have related company sales. And so for related companies, subsidiaries of a U.S. company, they are directly liable and create direct liability for sales to Iran and Cuba. So regardless of that it's a German subsidiary, they cannot exchange they cannot do business with Iran or Cuba without authorization from the United States. Is this recognized by WELL's management? Are these controls in place? How are sales reported to management? So we're looking here on other transactions other than Iran and Cuba that could go to embargo countries and see whether we have any U.S. persons involved in any way. A lot of companies that are multinational will rotate people from different countries to other facilities to learn the business and to broaden their base and also for their expertise. So do we have any U.S. persons located abroad who may have any authority over a transaction that the foreign entity is doing? Now all of a sudden we have created U.S. liability where it may have been okay for the foreign entity to do this, but now we have an approval process by a U.S. person. Perhaps the approval process is centrally located. As mentioned in the fact pattern, WELL has a global procurement process. Maybe they have a global sales process and it gets all reported back to U.S. persons, and now we may have a facilitation issue with regard to a U.S. person involvement. We have to also look at U.S. controlled components. If it's an integrated operation of production, we may be sending components from the United States. We have global procurement. We may be sending components from the United States abroad for use in the manufacture of items that may subject those items to U.S. controls for re-exportation. Recently acquired foreign subsidiaries of WELL can be a particularly cumbersome issue, a troublesome issue. If it was a foreign entity that was acquired by WELL, that foreign entity, it's not unusual for that foreign entity to have sales transactions with that are permissible under the country where it exists that would be impermissible if that entity is owned or controlled by a U.S. entity. So we have to, any recent acquisitions would get particular scrutiny to see how the due diligence was played on that. Now we have the next piece we have is to look at how transactions are controlled, and I refer to this as controls on transportation. Do we have a lot of goods shipped on an ex-works basis to a foreign person? Do we have any controlled goods sent on an ex-works basis to a foreign person? Controlled goods on an ex-works basis would indicate a significant risk, because now someone WOW, hard to do that way. Now WOW has a shipment to that they know is going to be exported and would require a license. Perhaps even WOW got the license, but they aren't controlling the exportation of the goods, so they wouldn't have control over the destination that it's actually going to. Is there an approval process prior to shipment? How about domestic sales to a domestic customer of controlled goods? Do they create any concerns? Generally not, but if it's controlled goods, we would like to see some communication by WOW that these items are controlled. Do they have a process in place for identifying red flags with customers? And have they seen this? Is there any way for to demonstrate that this has occurred? Are goods delivered to a freight forwarder? Are there communications regarding known exporters? Okay, we've got a question up here right now. It was asked, I've been told that a U.S. parent cannot tell a foreign sub that they cannot do business with, say, Cuba, as the EU has specific regulations around this, and can then raise a complaint with the U.S. government. Is this true? I think this question is referring to the blocking statutes that U.S. company that block the operation of certain U.S. sanctions or other country sanctions, and this is a very difficult issue to deal with, where you're between a rock and a hard place, because the United States will not honor that blocking statute as an excuse for doing the transaction. So you have to block the transaction, but you may be subjecting yourself to liability under EU rules. So you have to deal with it carefully on how you're going to be doing it. Ideally, you want to have systems in place to block them and not have the decisions working. But this could expose a company to multiple levels of liability. The last thing on transportation is really more just because it's going to limit your availability of information, is the idea of routed export transactions. And I use the census data. We referred to the ITRAC data on the import side, but use the census data as another objective source of data that we can use for due diligence. But in the framework of a routed export transaction, you'll see that it gives very little information. So it gives a shipment of aircraft parts. We don't know where they're going. We don't know when they went. Some of them don't have an ECCN noted on them. So we're going to have to try to match value and quantity to an export transaction and the level of detail that you probably won't have. So this really, if you see a lot of routed export transactions, you just have, it's a warning sign on making it very difficult to do the due diligence.
And then finally, on the export side, as we said we would discuss, we want to look at what interactions has the company had with the Department of State, DDTC, Department of Commerce, BIS, and the Department of Treasury, OFAC, related to exports. Obviously, high-risk items are going to be having audits directed, having no licensing or disclosure history, depending on the industry. I know that the Department of State has often said that healthy companies disclose. So if you get to a company that does not have disclosures, particularly if they're working in a high-risk area, it should raise a red flag, and you should start looking into probably their sales history and also get a hold of that product matrix, which also is a high risk that they don't have. Some medium-risk items would be voluntary disclosures. Again, this could signal either a very high-functioning compliance program within the company, or it could signal a company that does not necessarily take their compliance program very seriously unless it's disclosing every single day. You could have hardware export licenses only. Again, like WOW, when you have global operations and global customers, and you're an engineering company, you may be dealing with customers that have technical data needs. You may be exchanging technical data. And if you're not getting licensed for that, then while you may be compliant on your hardware, you're not going to be compliant with your technical data licensing responsibilities. Some low-risk items would be either a Department of State registration to manufacture USML-controlled items, or an encryption registration with the Department of Commerce to manufacture encrypted software or similar items. Export licenses, both for hardware and technical data, as we mentioned, as well as technical assistance agreements or manufacturing license agreements issued by the Department of State. And also, finally, and this goes to our product matrix, would be commodity jurisdiction requests to the Department of State, or CCATS requests for classification to the Department of Commerce. This shows that the company is taking is being careful to make sure that its classifications are correct.
And there's a question up here which is very good. We were focusing on economic sanctions and the export controls related to products and technology that are sent out. One person asked a question about anti-boycott requests, and I absolutely think that should be part of a concern. So I would look at where goods are sent to. There's the Department of Treasury publishes a list of anti-boycott concerned countries. That's not all of them, but it does give a suggestion on it, and I would look to that as seeing shipments to those countries shipments to those countries as a warning. And then often in the data room will be contracts for major transactions, and those should be reviewed for anti-boycott concerns as well. Those contracts will also serve a role in some of the sanctions issues that James referenced, particularly when dealing with Russia, for example. So as you can tell, we've gone through a lot of things that someone's going to be looking for, and it's, we've tried to do this in a way that walks through how the process would work with a company. But when operating on a due diligence program, you really need to have a checklist, an idea of where you're going at the outset. There's standard checklists out there. We're happy to send a checklist to anyone who's interested, and you can send us an email, and we'll forward that on. But what we really recommend is that the checklist be modified and reviewed for the target entity. So you may have questions that aren't applicable to some companies and are applicable to others, so you want to kind of target it. You also, as I mentioned earlier, have to think of this as an iterative process. So the checklist is your starting point, but you may be drilling down with successive levels of questions as you get answers to some of your points. The last piece is to document the due diligence, and the checklist is a step to doing that. The documentation does a couple things. It helps your deal people and going forward, and may, if things go south later, document where you were and what information you got back. But it helps to start a roadmap for the integration process and what issues you've identified as part of the due diligence review, and should the sale go forward, or the acquisition go forward, that that the trade compliance has a roadmap to go where they're going to attack first, and trying to solve the problems that they've seen to be most acute. Here's our contact information. Feel free to contact any of us with any questions you may have offline, or if you would like a copy of a due diligence checklist. And then thank you very much for participating. I hope this was useful.